We're going to proceed to questions now from the members of the committee, and I'll start with my own questions, and I guess I'll start with Professor Vladeck, if I may. Many people looked at the fact that the Regal decision was decided with an 8-to-1 vote by the Supreme Court in favor of preemption as evidence that it's clear that all FDA product liability cases should be preempted. I wanted to ask you, how could the court be wrong about that when it was such an overwhelming margin? Can you explain why the Regal decision was 8-to-1?
I can take the court at its word. What the court said was, and this goes back to an earlier decision by the court in the case involving cigarette labeling chip alone, many statutes that have preemption provisions use the same language. And the language is requirements different from or in addition to those prescribed by federal law. And the battleground since 1992, if you can believe it, has been over the word requirement. And in chip alone, where Congress itself wrote the warning label, the court said that it would be odd to hold a tobacco company liable for failing to add a warning that Congress itself did not write. And so there in chip alone, the court said the word requirement could, in some cases, include common law remedies under tort. And since then, there's been a series of decisions discussed in both my testimony and Mr. Cooper's testimony, in which the court has vacillated on what the word requirement meant. Finally, and Justice Stevens' concurrence makes this quite clear, finally in Regal, the court simply gives up the ghost and says going forward, the word requirement should be understood to include common law tort remedy.
But what about, some of my colleagues made statements that they were here at the time, that wasn't the intent. Was that any of that information, they just ignored it or what?
Yes, the court just ignored it. And this is part of the court's new practice pushed by some of the justices on the court to look simply at the text of the statute and not to look at the statute's purpose or the underlying legislative history. The legislative history of the statute is quite clear. Congress did not mean to wipe away tort remedy for people injured by medical devices.
Okay.
And there's no argument on that score, I don't believe.
Oh, I appreciate it. I think it's important. Now, the device industry is arguing that a bill overturning the Regal decision like mine would dramatically change the legal and financial landscape for device companies. But would this bill really change the status quo? I mean, my understanding is that device companies face state tort suits right up until the Regal decision. So what's your opinion on that?
Right. I think that's true, though, with a caveat. Prior to Regal, the courts were divided on whether there was preemption of these kinds of cases. The majority of the federal circuits had ruled that there was preemption. None of these decisions, however, came before the mid-1990s. All of them are post-chip alone, post-1992 decisions. So none of the device manufacturers even argued preemption until post-chip alone. So it is true that in some jurisdictions and in many circuits, from maybe the mid-1990s through 2008, there was a preemption defense available to these kinds of devices. But if you look at the history of medical devices in the United States, they predate by decades the medical device amendments of 1976. We've had life-supporting and life-sustaining medical devices on the market for 50 or 60 years, and only in that one brief interval, that maybe 10 years, post-chip alone and pre-Regal, was there real preemption available. And even then, it was no guarantee because device manufacturers could be sued in some jurisdictions, including what some have colorfully referred to as the crazy 11th Circuit.
Well, let me ask you this. You heard some of my colleagues say that the most frequently repeated objection to my bill is that it will create 50 state FDAs and that devices will be regulated differently in different states. And then I think Mr. Cooper stated that products liability cases constitute a kind of regulation in disguise. I mean, what is your opinion about
I think that's an overstated argument. I mean, for every other consumer product, except where Congress has expressly preempted state tort law, we see parallel enforcement of state regulation, of federal regulation of products, and it's cars cell phones, virtually any other consumer product that complements state tort law. They serve distinct functions, although they're somewhat overlapping. I think it's an overstatement to say that a state tort judgment is regulation in any meaningful sense. It isn't. It is not device specific. It doesn't tell the manufacturer that they must do anything. And for that reason, we have seen tort law and federal regulatory law coexist in virtually every sphere of government and private industry that we have in the United States. And this complementary role serves an important purpose. One is it compensates people injured through no fault of their own. And second, it deters excessive risk-taking. We can go up and down the list in terms of massive recalls of medical devices. And here, remember, most of these recalls are where, Mr. Cooper talked about who makes the decision about defect. Well, in virtually all of these cases, it's the manufacturer and the FDA. The Sprint Fidelis lead is being recalled because both agree it should be recalled. Bork-Shiley, heart valve, 55,000 people. The Sulcer heart valve, another 35,000 people. The Medtronic pacemakers. All of these products were recalled after serious defects emerged, and both the FDA and all of the experts there and the company agreed it was time to get the product off the market. That serves, in most of these instances, tort law served an incredibly important informational function. That is, we learned about the severity and pervasiveness of the defect through tort litigation, not through the imperfect adverse rewarding mechanisms that the FDA has.
Thank you, Professor. Thank you for your enthusiasm, too. The gentleman from Illinois, Mr. Shimkus.
As much as you don't want to go to me, no, thank you for the panel and a compelling testimony. I left. One of the challenges of our jobs as member of Congress is we hear tough stories all the time, especially in the Health Subcommittee. I left here to go to this ALS lobbying day. I had folks in my office. So these are things we deal with on a daily basis, maybe multiple times. So we appreciate you all being here. Ms. Robb, can you give me the timeline? You were diagnosed, when the implantation occurred in 2005?
I was diagnosed in February of 2004, and the implantation was in May of 2005.
And what would have been your health condition had you not had the implantation?
The device was simply implanted as a safety net. It didn't do anything on a daily basis. I didn't use the pacemaker portion of it. It just was simply there in case I were to have a fatal arrhythmia to hopefully shock me out of it and save my life.
Right.
So I was on a course of medication that was increasing my heart function, and I was doing really well.
Yeah, good. I think that's helpful, and I appreciate that. Let me turn to Mr. Kinsley. I'm a St. Louis area member of Congress from Illinois. Of course, those of us who follow the St. Louis Cardinals are huge Jack Buck fans, who was suffered from Parkinson's, and you would not have known that had you not seen him, and because his voice was still strong. When you moved from your chair, from where your seat was to Mr. Cooper's seat, had you not had the implantation, how long would that have taken you to do?
Well, it would have taken a few seconds longer, probably. I mean, I can't be more specific than that.
So the implantation for you has been pretty much, as you stated in your testimony, very helpful in obtaining a livelihood and your standard of living.
Yes, it's been essential, I would say.
In your testimony, you also talk about the problem of having two independent systems, the FDA and tort law, for making the decision on whether a device should be on the market. Can you talk about this and explain this analysis of the problem?
Well, you've got the FDA ruling, and you've got tort law essentially trying to do the exact same thing, which is to balance the risk against the benefit. And I was amazed to hear that well, let me start again. I think that surely tort law does draw a line under the behavior, affect the behavior of companies that manufacture devices. And any company that loses a case and then continues to manufacture the device anyway would do very badly both in the market and before this committee. That would be crazy. So I think it's undeniable that these are both systems that affect the decisions of medical device companies. And I think, in effect, the company does whatever is between the two is the most restrictive.
Thank you. Let me go to Mr. Cooper real quick. Does a patient have a right to sue the device company if it fails to follow FDA requirements in manufacturing the device?
Yes, the Regal decision following the Lohr decision made it absolutely clear that states...
Let me go to the next one. That's fine. Does a patient have a right to sue if the device labeling is inconsistent with FDA requirements?
Yes, if the...
Okay, let me go to the next one. Does a patient have the right to sue if the company withholds data from the FDA?
Probably not.
Okay, does the patient have the right to sue if the company misleads the FDA as to the device's safety and effectiveness?
Same answer, but FDA has tools, including criminal prosecution, to deal with that kind of problem.
And I was going to follow up, Mr. Chairman, with just a question from Mr. Cooper. Can you expound on small business implications of this legislation?
Yeah, I'll give you an example. One of the areas that at least some years ago was grossly underserved was medical devices, including breathing instruments and the like, for prematurely born babies. That's a high litigation risk area. A company that develops a product, and there are some products, but a company that develops a product in that area is taking an enormous risk of litigation because nothing that humans make is perfect. Nothing in medicine is perfect. I'm not a doctor, but that's my understanding. Not medical devices, not drugs, not surgical procedures, not laboratory tests. Nothing is perfect. They all fail sometimes. And if you get failures in that area, you're going to get litigation and you're going to get enormous judgments. And small companies, that doesn't make sense. And that's where the innovation is, mostly, in small companies.
Thank you, Mr. Chairman. If I could ask unanimous consent to submit 2 letters, one from the Vietnam Veterans of America and also from Mr. Albert Dom, who's in a similar situation of the benefits of this this type of technology.
Without objection, so ordered. Mr. Braley of Iowa.
Thank you, Mr. Chairman. One of the comments that was made earlier in the hearing was that preemption is not a get-out-of-jail card. Professor Vladeck, that's not true, is it? That's exactly what preemption is. It's a bar to the courthouse door.
It is.
And in fact, Justice Ginsburg mentioned that in the concluding paragraph of his dissent where he writes, the court's broad reading of Section 360K, parens A, saves the manufacturer from any need to urge these defenses. Instead, regardless of the strength of a plaintiff's case, suits will be barred ab initio. That means before they're even filed.
Well, they'll be dismissed as soon as they're filed.
Exactly. And if this is a well-known legal doctrine, then people aren't going to take those cases and they're not going to file them.
That is correct.
One of the other comments was that this was going to dramatically increase the number of lawsuits against medical device companies, but until the Rigel decision clarified this conflict within the circuit, there was nothing that prohibited somebody from pursuing this type of relief. So the same pace of claims is likely to occur whether or not this act is passed.
Right, which is why we're seeing so many cases dismissed in light of Regal.
Exactly. Now, one of the other comments that was made, I think it was by Ranking Member Barton, was quoting from the Republican Staff Committee brief. And he mentioned that this act, if passed, would severely disrupt innovation in the medical device industry that has existed since 1976. But you pointed out this same dual enforcement mechanism has existed literally since the act was passed. So any innovation that has been proceeding apace since 1976 should not in any way be affected by this.
That is correct, and even well prior to 1976. We had medical devices prior to Congress's passage of the medical device amendments.
Thank you. Mr. Kinsley, I want to ask you a little bit about what your concerns are specifically related to the role that tort liability litigation plays in medical device and pharmaceutical claims. Based upon your background, I assume that you are a firm believer in the Constitution.
Yes.
And that includes the Bill of Rights.
Oh, sure.
Which, as we know, includes the right to free speech and the right to freedom of the press,
Right.
which gives you the ability to do what you do for a living.
Right.
Are you a supporter of the Seventh Amendment to the Bill of Rights?
Which one is that?
It's the one that says in suits at common law, where the value in controversy exceeds $20, the right to trial by jury shall be preserved. Do you believe in that amendment?
Well, it doesn't, it's not one that gets my heart beating faster.
Well, let's talk about that, because you understand the historical perspective that led to the passage of the Bill of Rights.
Well, let me say something about the Bill of Rights. I'm in the one industry that is protected from malpractice lawsuits, which are called libel suits in the world of the press. And the Supreme Court, as I'm sure you know, has said that because of the First Amendment, we are protected even when we have committed malpractice by making a mistake. New York Times against Sullivan. Every other industry does not have that advantage. This is just the opposite of most countries, such as in England, where journalists live in terror of lawsuits and everybody else is rather calm about it because they somehow or other manage to have a system that brings justice in most cases without a lot of the absurdities that, in my view, attach to product liability in this country.
Well, you understand that even journalists are subject to liability under certain circumstances when they engage in libel and slander, and there's differing degrees of proof whether you're a public figure or not. And that all factors into determining whether there is accountability. And in fact, some journalists have been held accountable because they took unreasonable risks with what they say about them.
Yes, you have to try really hard
Okay,
to
well
be
then,
sued.
let's talk about that, because one of the things that we know is if you are going to sue the manufacturer of a defective medical device, not anybody can do that. Did you realize that?
What do you mean?
Well, in order to bring that claim, you have to prove the manufacturer made a defective device that was unreasonably dangerous, that caused direct harm to someone. And even if you can prove that, and you're the device manufacturer, you have an absolute defense to those claims if you can prove that the product you introduced into the stream of commerce conformed to the state of the art at the time that product was manufactured.
Well, as I said at the beginning, I'm not an expert in this field, but I do think that as a general rule, our society is overly risk averse, and we pay for that.
But in this case, if you're the device manufacturer and this state-of-the-art is an affirmative defense that gives you complete immunity, you can walk into court and say, hey, the FDA pre-approved my product. That was the state-of-the-art at the time that manufacturer that product was introduced, that's my get out of jail free.
Well, that seems like a good get out of jail free card.
And that exists
Well,
right
we're going to
now.
have to, we're a minute over, so I know
Thank
you
you,
two are
Mr.
having
Chairman.
such a good time here that I didn't really want to stop you, but thank you. Mr. Burgess?
Thank you, Mr. Chairman. And I was enjoying that. It took me back 15 years ago when I was a physician in practice and every night would turn in Crossfire and watch you and Bob Novak go at each other. And I used to enjoy those exchanges as well. What concerns me today is I agree with you more than I recall agreeing with you 15 years ago. And I must admit, I guess things have changed in 15 years. Let me ask Dr. Kerfman, and I probably need to ask Dr. Meisel the same question. Both physicians, can you help us understand the physician's role in helping to evaluate and helping the patient understand the risks and benefits associated with any complex medical technology? That role does fall to the physician, does it not?
It is a common role for physicians to serve as counsel for patients when determining the risks and benefits of any therapy, whether it's a medical device, a drug, or some procedure. I think it's incumbent upon physicians to have accurate and timely information, and one of the things I as a physician have struggled with is dealing with medical device malfunctions with incomplete information, inaccurate information, or a lack of timely information in handling these cases. And of course, we all rely upon the Food and Drug Administration to help us with those determinations. Do you ever find yourself in the course of clinical events reviewing court cases to find out if a device, if you should be counseling your patient based upon what's happened in the legal system? I'm not sure I'm the right person to ask that question. I do review the court cases. I find them extremely interesting. I think there's a lot of very interesting information about device reliability that's in those court cases. I think a lot has been learned from those court cases, and there are things in those court cases that are released because of the court cases that otherwise wouldn't be released, including FDA documents.
Let me ask Professor Vladeck, you, in response to a question posed by Chairman Pallone about the 8-1 decision of the Supreme Court, was this consistent with what had been the decisions of lower courts, or did they depart from lower court decisions?
I think it's fair to say that many lower courts had reached the same conclusion that the Supreme Court did. I think it's also fair to say that there were many courts, particularly state courts, that did not. And so you had a deep division within our judicial system about the proper reading of the preemption provision of the medical device amendments.
But it was not inconsistent with what the lower courts had ruled. So in that aspect, did not alter the regulatory environment.
Well, remember, no court had ruled that there was preemption under the medical device amendments until the mid-1990s. And so to the extent there was preemption during this period, one is it was recent, and second, it was incomplete, because plaintiffs could engage in forum shopping, and where possible, they'd sue in the jurisdictions that permitted these cases to go forward. So it is not as though prior to Regal, any medical device manufacturer had an assurance that a claim would be preempted.
And who would engage in the forum shopping?
The plaintiffs, yes.
Yeah. Yeah, I
It's
thought
only
so.
bad when the other side does it.
Mr. Cooper, let me ask you a question, if I could. Some suggestion that the effect of the Regal decision is to provide broad-based immunity in instances where the medical device failed, the get-out-of-jail-free card versus don't get out of jail free. So would you agree with that? Do you think that is true?
No, I would not agree with it, Mr. Burgess. The Regal decision applies only to devices that have gone through the PMA approval process. That's about 30 products a year, less than 1% of all the devices on the market.
Under current law,
does the patient have the right to sue the manufacturer if the device fails?
People can always sue. Whether they'll win is another matter. And if a manufacturer has, as I discussed earlier in answering some questions, if a manufacturer fails to comply with FDA requirements in the conditions on the PMA approval or the manufacturing process, Regal would not provide any defense. The real problem I think we're grappling with here is that medical devices are going to fail even if they are the best that human beings can make. And how do we take care of the people in whom they fail or for whom they fail? And that's a matter of health insurance or disability insurance or life insurance. It's an insurance system, and the product's liability system is not intended to be an insurance system. It's based on fault or defect. And if the product isn't defective, if the manufacturer is not at fault, then the plaintiff should lose. That's our legal system.
Let me, in just the brief time I don't have left, if on the physician's part, the physician utilizing the device, if they commit an error either in diagnostics or application of the device under Regal, can they be sued?
Yes. And in Levine, for example, the doctor, the clinic, I guess it was, settled. And if you look at the facts in the Regal case, the physician who was applying the catheter, the balloon catheter, misapplied it in violation of the labeling. Nevertheless, plaintiff sued the device manufacturer.
Okay, we're going to move on. Thanks. Gentlewoman from Florida, Ms. Castor.
Thank you, Mr. Chairman. Thank you all very much for being here today. Some device companies have argued that the pre-market, that the impact of the Regal decision is limited numerically because it only applies to PMA devices. Mr. Cooper just made the argument that it only represents 1% of all medical devices reviewed by the FDA. But is this a fair representation of Regal and all of the devices, Dr. Maisel? Does that 1% figure accurately represent the actual usage and importance of PMA devices?
The best term I can come up with to describe that number is propaganda. The repeated use of the 1% or we've heard 2% number is fuzzy math. The devices that we care about are not tongue depressors and bedpans and stethoscopes, which are included in the 99%. We care about the important life-sustaining devices whose safety patients rely on. And those devices, we've also heard a number of approximately 30 new PMA applications a year. Well, the FDA actually sees over 1,000 PMA and PMA supplement applications each year. So it's much higher than that number. And if you think about the number of patients affected by these devices, it's in the millions. There are more than 10 million Americans living with permanent implanted devices right now, and there are hundreds of thousands, if not millions, implanted each year.
And what type of injuries and what type of patients?
Well, these devices are, in many cases, are life-sustaining devices. We've heard from a patient today here on our witness stand that received painful shocks. There are devices that can fail to deliver life-sustaining therapy when needed. There are pumps that can under-deliver or over-deliver medication. There are stents that can malfunction. Every product has the potential to malfunction. And I'd like to just clarify, I agree. I don't think a malfunction should equal liability for a manufacturer. That's not what we're talking about here. We're talking about a manufacturer that fails to meet the standard of care, that fails to produce a product that's as reliable as it should be.
And Professor Vladeck, it's unclear to me, does the preemption apply even when the corporation or folks in the company knew or had knowledge that the device was defective even after they received the FDA approval?
Yes. And even where the company receives the FDA and fails to provide information to the FDA, there would be preemption not under Regal, but under prior Supreme Court decision called Buckman versus Plaintiff's Dignity.
So, Mr. Kinsley, I'd ask you, what about those cases when folks in the corporation or the corporation or personnel knew of the danger? Does it make sense that consumers are barred from seeking compensation for their injuries and lost wages?
When you say knew of the danger, if this company has met FDA standards, and what they knew was that there's something, I mean, either it meets the standards or it doesn't. And if it meets FDA standards, then you shouldn't have to meet a whole nother.
But even
set
if they
of
knew
standards.
that the device was faulty and could cause
Well,
injury, you're saying that if FDA signed off on their...
presumably, what they knew was, well, if what they knew was that the device didn't meet FDA standards, yes, of course, they should be liable.
I think the case is that they receive the pre-market approval from the FDA that is supposed to mean something, but they had, even in the cases, they had knowledge that the device could cause injury.
Well, I think some things I've heard today and things I knew even before suggest, and I think everyone here agrees, that the FDA could use a little bit of improvement. But
Well, it would seem to me that the companies in those, in that case, have a responsibility to be truthful in the FDA process.
Well,
FDA
sure,
pre-market
I would
approval
say
isn't
if the company is
blessing.
lying, even if it's lying about a product that does meet FDA standards, that's not good. And they should maybe lose this immunity they get.
Thank you very much.
Thank you. Gentleman from Indiana, Mr. Boyer.
Mr. Kinsley, I will be your lifeline. Okay?
Thank you.
I will be your lifeline because I disagree with the professor's testimony. The professor's testimony said that federal preemption will give protection to a manufacturer if, in fact, they voluntarily withhold information, i.e., that's wrongful conduct. Or lying, that's wrongful conduct. So if a corporation is involved in wrongful conduct, they are outside of the federal preemption, as according to the Supreme Court decision. Isn't that not correct, Professor?
The decision I was referring to.
Wait. Is my analysis not yet? Is that not correct?
I believe it.
First, Professor, do you have the mic on?
I do.
All right, go ahead.
That analysis
I
I
believe
gave,
it's
Professor.
incorrect under the Supreme Court's prior ruling.
Professor, time out. The analysis that I just gave, according to Regal, is that not yet correct?
Preceding Regal is Buckman. Every lower court to address what I believe is the question you're posing has said that that is essentially a fraud on the FDA claim, which is preempted. And maybe I misunderstood your question, but
it is clear, I believe, it is clear after Regal that if a manufacturer of a PMA device, in fact, commits wrongful conduct, it can be held liable. That's my lifeline to you, sir. That if somebody is lying, they voluntarily withhold that information, you do not get the shelter of the law. If you participate in wrongful or criminal or conduct that will be harmful to our society, you don't get the shield of the law. That's Regal, is it not?
I would hope you were right. Let me just make two caveats. With all respect, I think the lower courts have not read Regal to overrule or to in any way affect Buckman. And if you look at the cases cited at footnote 25 of my testimony, many of them discuss precisely that issue. I would agree with Mr. Cooper that the sanction that would be available would be the FDA bringing an enforcement action against the company. And the FDA plainly would have the authority to go after the company for doing that conduct and could proceed criminally. So I'm sorry.
Is your background in tort law?
I've done tort law, yes, sir.
Under products liability law, help me, I'm just a country lawyer. So under products liability law, a device manufacturer's liability must be based on some type of fault. Is that not true?
That's correct.
Some type of fault. So if a manufacturer, though, abides by the rules, the regulations, the procedures, the law, where are they then at fault?
They're not at fault. And,
Right. And that, in fact, is the importance of the preemption, the shield to that manufacturer in the pre-market approval process, correct?
I think I understand you, yes.
Yeah. And so that's basically, that's why I'm saying, all right, the Supreme Court, I understand why you then have made that as a ruling, to bring clarity then to all of the other courts and jurisdictions around the country accepting the hiccup.
Well,
That's the
and many
11th
state
Circuit.
courts. You're correct that only the 11th Circuit in the federal courts.
I'm referring to the federal courts.
Okay.
And you would agree with that?
I'm sorry?
And you would agree with that? Or what I just said with regard to there's one circuit that was out of balance with the
Goodland,
others.
right. That is correct.
Okay. So back to my lifeline to you. I mean, I just want to be really clear here that if, in fact, there's a manufacturer, Mr. Kinsley, that in fact has lied, they don't get the protection of the law. And I don't think any good manufacturer out there wants there to be protection against anyone who's not playing by the rules. If they play outside the foul lines, they should feel the full wrath of the law. Would you not agree?
Thank you for that lifeline.
I just don't remember that on Crossfire. I don't remember that. Here's the other point that I had to make in my opening, and it really does concern me because in the 17 years I've been up here, I've been a strong advocate of our country being able to attract great minds from all over the world to come to the marketplace, at-risk capital, push the bounds of science to the benefit of our society and then unto the world. If, in fact, we pass a law like this, what are the consequences? Let me turn to you, Mr. Cooper. What are the consequences going to be upon not only innovation, but will there be a quilt, sort of a patchwork in the marketplace with regard to where manufacturers are going to go to sell their products for fear that one state may, in fact, have a different litigious environment?
Well, there may well be some of that. I think the major impact would be lack of development of products where there is great need, but also great liability risk. I think the experience of lawyers who try products liability cases is that juries will do what they need to do to compensate an injured plaintiff. If they have, even if the manufacturer had a warning that said, don't do this, it will kill you, the jury will find that that was inadequate because it could have said it will kill you for sure. And that's a natural human reaction. And it's a problem. And the effect of it is on people who need medical devices, and they're not there, or they haven't been improved to the extent that they could be if more investment were made, but the manufacturers decided to put the investment somewhere else, which presents less liability risk.
Thank you. Thank you, Professor.
Thank you. The gentleman from Utah, Mr. Matheson.
Thank you, Mr. Chairman. I think this topic is certainly an important issue. It represents an intersection of a number of key dynamics, including patient safety and health care and innovation. And while we all agree that patient safety should be a top priority, I think we probably all agree that if a device maker has done something wrong, they should be held accountable. But what I'm concerned about is that a blanket approach could have some far-reaching consequences. If the problem lies elsewhere, say with the review process at FDA, then this committee needs to have a larger conversation beyond this preemption discussion we're having today. I don't think we should take this issue very lightly, and I think we ought to be really careful and not rush legislative action. I had a number of questions, all of which have just been covered except one, and I'll just ask real quickly to Mr. Cooper. How should we address this issue with the FDA? Do they need more power, more authority? Do we need to change the way they're structured to protect consumer safety related to medical devices?
I think they need additional resources. I think they, as several members have said, the agency has been underfunded for a very long time. The President's budget makes some headway on that with some substantial increase, including for safety-related related projects. More needs to be done. And there also needs to be good oversight. My experience at FDA was that nothing concentrates the mind like an upcoming congressional hearing, particularly one by the Oversight Subcommittee or the Health Subcommittee of this committee, which has a long and distinguished record of very effective oversight of the agency. I think that's needed as well. But FDA has wonderful public servants, dedicated career people who could make a lot more money doing something else, but derive much value in their lives from serving the public. And on the whole, I think they do a very good job. It still could be improved because the problems they deal with are immense.
All right. Thanks, Mr. Chairman. I'll yield back.
Thank you. Gentleman from Georgia, Mr. Gingrey.
Mr. Chairman, thank you. I want to address my first question to Mr. Cooper. The medical devices that we're talking about that are highly regulated by the FDA, if you would just walk me through the process to approve one of these new devices and discuss the types of post-market surveillance that is typical of these devices in order to identify higher than expected complication rates and notify patients and physicians of any failures.
Well, to try to do it very briefly.
Yes, please.
As has been stated, the applications tend to be voluminous. FDA needs to understand what the ingredients or materials, the components of the device, the principle of operation, what its intended use or uses are, what kinds of problems it's to deal with. There will be clinical studies, preclinical studies. There will be laboratory studies. The raw data of all of that and the analyses all go to FDA. FDA does its own review, its own statistical analyses. It can require the companies to do additional studies. Proposed labeling is submitted. The FDA can ask for samples. So it does a truly comprehensive review of all that is known. As has also been pointed out, the studies are limited in terms of the number of patients and the duration of the studies. If you waited forever, you'd never have any devices approved. So you have to cut it off and make a reasonable judgment at some point. And then FDA has to conclude, and people have to sign their names and be accountable, and they are accountable, for concluding that that there is an assurance, a reasonable assurance, that the device is effective for its intended use, and that it's safe. And safe means not that it's harm-free or risk-free, but that the benefits of the product outweigh those risks. And then it approves it. And it can approve it with various kinds of conditions, including conditions for further studies as the patient population using the device expands, sometimes exponentially beyond the limits of the clinical trials, which are the primary basis for the approval. Manufacturers are required to submit promptly to FDA reports of malfunctions or adverse events associated with the use of the device. Device user facilities, hospitals, clinics, and the like are also required to report. Physicians, patients, and others are encouraged to support, and you can go to the FDA website and do that. The medical literature is reviewed both by the manufacturer and by FDA, and in their annual reports, the manufacturers are supposed to update FDA in that area.
Mr. Cooper, thank you. I'll reclaim my time. I did want to thank you for that response. Ms. Robb, I wanted to ask you, and thank you so much, of course, for being a witness, and I'm sure it's very difficult for you to describe that harrowing experience that you went through several years ago. But let me understand, the defibrillator that was implanted, I'm assuming that the physician, your cardiologist, decided that you were at great risk because of this cardiomyopathy and I guess some congestive heart failure as well, of going into what we in the medical field call ventricular fibrillation, not atrial fibrillation, not supraventricular, but ventricular fibrillation, which and I'm sure you were told that this could be result in sudden death. So you had this surgical procedure, you had this defibrillator inserted because if all of a sudden you went into ventricular fibrillation without that device to give you that shock, pretty good jolt, as you described, when it started shocking you maybe inappropriately. But if it had shocked you in the appropriate manner, that is because you truly, your heart had gone into ventricular fibrillation, that device would have, or certainly was intended to save your life, was it not?
It was definitely implanted in me to save my life. I had never been shocked before December 31st when it malfunctioned. That was the first time that I'd ever been shocked, and it was 31 times. But it was put in as a safety net in case I were to go into VTAC.
Would you agree that you had that put in because it's better to have it and not need it than to need it and not have it, and that?
Definitely.
Yeah.
I would say that. You know, at the time, I knew that they have a sort of a cutoff limit with your heart function. When it gets below a certain level, you're at an increased risk to go into VTAC, and they recommend to get a defibrillator as a life-saving.
Right. Well, let me reclaim my time, and thank you.
Okay.
Thank you for that response. Mr. Chairman, I just want to say that this is a great hearing and an opportunity to hear from some real experts and anecdotal testimony from Ms. Robb and actually from Mr. Kinsley as well. It's not easy. This is tough. I'm a physician member. Some of my colleagues on this panel or on this committee and subcommittee are physician members and understand that this is a tough issue. So I appreciate you being here and giving testimony and helping us weigh the pros and cons of this legislation. And with that, Mr. Chairman, I'll yield back.
Thank you. I think we've finished with our questions, but I do want to thank all of you for being here today. I agree with what Mr. Gingrich just said, that this is, you know, something that we obviously take very seriously, and we have to decide what's the best course of action. And I think all of you have really helped us in, you know, commenting on this legislation and, you know, as we move forward. So thank you all very much. I will tell you that, yes. Yeah, oh, absolutely. What happens procedurally is if members have questions, they can submit them in writing, and you should be notified within the next 10 days if there are questions of that nature, and then we would ask you to respond in writing, and that's the way we proceed. But again, thank you so much, and without objection, the meeting of the subcommittee is adjourned.